this video is useful for you if you've been recently made redundant or if you know someone who has recently been made redundant. And this video applies to anyone in Australia as long as you worked for a national system employer. A national system employer is basically a company. It can include a few other entities. So if you are unsure whether you worked or are working for a national system employer, click on the link in the description below and that will take you to some useful information so you can work that out. The first piece of advice I have for you is to double check whether your redundancy is a genuine redundancy. A genuine redundancy occurs when the employer no longer requires the position the employee is performing to be performed by anybody. So for example, if you're working for a cleaning company and that company employs 4 cleaners and management makes a decision that they can no longer afford 4 cleaners but they can only afford 2, so therefore 2 of the positions would be made redundant. It's important to remember that redundancy is about making the position redundant, not the person redundant. So if the business still requires that position to be performed, then it's very likely that there is no genuine redundancy. And if there's no genuine redundancy, then the employee may very well be entitled to make an unfair dismissal claim. It's important, if you're thinking of making an unfair dismissal claim, that you file your application with the Fair Work Commission within 21 days of your termination taking effect. There will be a link in the description to provide you more information about unfair dismissal. The second important thing to consider when examining whether there has been a genuine redundancy is to ask the question whether the employee who has been made redundant could have been employed elsewhere within the organisation. This basically means that the employer could have found the worker another job. So let's go back to that cleaning example I mentioned a few moments ago. If the cleaning business could have employed one of the redundant cleaners as a driver, then there has not been a genuine redundancy insofar as it concerns one of the cleaners, and the business will be potentially exposed to an unfair dismissal claim, and one of the cleaners or both of the cleaners could very well launch an unfair dismissal claim against the business. And the third and final thing to consider insofar as it involves genuine redundancy is to consider whether any consultation requirements have properly been complied with. To do this, you need to examine whether a modern award or an enterprise agreement applies to your circumstances. If a modern award or an enterprise agreement applies, then they may very well be obligations on the business to consult with the workers before a redundancy occurs. This means that when the business has made a decision to make the workers redundant, it needs to communicate with the workers and give them an opportunity to respond before the business starts making the workers redundant. And this communication should occur in writing. If these consultation requirements have not been properly complied with, then there is not a genuine redundancy, and the workers may very well have a claim for unfair dismissal. If you are unsure whether you are covered by a modern award or an enterprise agreement, then I strongly suggest that you contact the Fair Work Ombudsman. Click on the link in the description for the contact details for the Fair Work Ombudsman. Thank you for taking the time to watch this video. If you have any questions, please feel free to post them in the comments section and we will take them into account when creating future videos. And also don't forget to subscribe. Thanks guys.